This is Philip Schrag, and I'm talking with David Vladeck, who represented Howard Wieder in the New York State Court of Appeals. How did the Wieder case come to your attention?
Actually, through my mother. My mother is an employment lawyer in New York City. She had seen this case reported after it had been decided adversely to Mr. Wieder in the trial court, and she and I handled this case both in the appellate division, which is the intermediate court in New York, and in the New York State Court of Appeals, which is the highest court in New York State.
What was the most important strategic choice you had to make as you prepared to argue this case?
Our case rested on two legal theories. The first was that the law firm committed a tort when it fired Mr. Wieder for reporting an ethics violation. The second was that the firm breached its contract to Mr. Wieder by frustrating the purpose of the contract, which was to permit Mr. Wieder to provide legal services. And obviously, from a recovery standpoint, the tort remedy is the favored remedy. It provides greater damages and the possibility of punitive damages in New York State, whereas the recovery under contract is, of course, reduced through mitigation and other contract offenses. On the other hand, Mr. Wieder felt very strongly that the contract theory, although it would bring less recovery, was in some ways a better theory because it was more consistent with his interest in the case, which was vindicating his right to practice law in a way that was consistent with the ethical duties. And so, even though it may have diminished his recovery, Mr. Wieder very much wanted to press the contracts theory.
And that was the theory that prevailed.
That was the theory that prevailed.
What were you most worried about in the Court of Appeals?
Well, apart from the court simply saying that he was an employee at will and only the legislature could make exceptions to it, I was worried about the concern that law firms, as hierarchical organizations, require associates to, in some degree, defer to the judgment of their seniors. Here, the ethics violation was clear-cut, but in many instances it will not be. And the question really, I think, that I was most concerned about was whether at times it makes sense, or at least is ethically permissible, for a senior partner in a law firm to overrule a junior, inexperienced lawyer about the requirements of when reporting is necessary. And fortunately, that issue never surfaced in the litigation, but I was always worried about it as the litigation ran its course.
And was there anything particularly interesting that happened at the oral argument or about the oral argument?
Yes, the chief judge of the New York Court of Appeals at the time was a very celebrated jurist by the name of Sal Wachtler, a brilliant, energetic jurist, often mentioned on short lists for the United States Supreme Court. The argument took place in the afternoon. Judge Wachtler was completely in command. A month later, he was arrested by both the Federal Bureau of Investigation and the New York State authorities for harassing and threatening a woman with whom he had an extramarital affair. It turned out from the FBI reports that the last act of harassment preceding his arrest occurred the very morning of the argument in Wieder, 4 hours